I welcome you in the 8th lecture regarding the legal compliance for incorporating startup, and I am in the module called Incorporation of Partnership, LLP and Cooperatives. And in this talk, I will concentrate more on how to incorporate limited liability partnership. Now, in my previous lecture, I talked on what are the laws relating to incorporating a limited liability partnership and how you can govern that, what is the management issue, can you restructure the LLPs, and at the same time how to dissolve or wind up the LLP. But in this lecture, my attention is more on how to incorporate LLP in the given framework which I have talked with you in the last lecture. Now, most important thing in case of the LLP is choose the name, and to choose the name you need to see that the name which you are finding, it is not similar with the existing limited liability partnership. And if you go further, then it says that it should not be deceptively similar or similar with somebody's trademark or the business mark or some kind of identification by which a business been identified or the name of any existing corporates. And if you do something, then in that case, I mean, if it is really similar to something, then you might not get this particular name for the incorporation. Now, there is a lot of development has happened in this regard, and you will find that I have given a URL in this particular slide itself, and you can visit that particular URL of MCA, that is the Ministry of Corporate Affairs, MCA 21, and they have provided sort of a link wherein you can find out that the name which you are looking for, is it available or not. Now, there is a prescribed form is there, you have to fill up this particular form and you have to give alternative names, and you need to apply to the registrar of the LLPs to find out that that particular name is available for you to register your business. So, choosing a name is a time taking process, and you need to do it carefully, because many people who are related to the business and the marketing, they say that branding of an organization is very important. So, branding also indicate the many things, like how you pronounce the name, what is the spelling of the name, how it looks or visualize, what are the color combinations, so much so forth. So, possibly you might need to take some kind of a professional advice to develop this particular thing, but before that you have to choose the name. While you are choosing the name, you need to find out that the pronouncing or the looks of that particular word should not be similar to each other. So, like let me give you some example, like you find that there is a organization called KFC, who basically in the food chain, and sometimes I found that people write in the same color and in the same font as AFC. So, sometimes it is very difficult to understand that it is actually the KFC they are indicating or AFC, because you might not able to recall that it was a KFC and now you are looking at AFC, but in a similar which looks similar. So, these are called deceptively similar, and you should be careful while you are choosing the name for your startup and you want to incorporate your startup as LLP. Then the second important thing is a preparation of the document. Now, what is the incorporation document, I have discussed with you in the last lecture. Now, I am going to talk more on this particular incorporation document, because statutorily you need to give some information in this particular incorporation document. but it is advisable if you can detail out this incorporation document and incorporate more information relating to the capital contributions or ownership structure, relating to the management, relating to the transaction process, and so much so forth. Even if you wanted to go for a restructuring of this company, you wanted to get a fresh partner admitted into this particular system, and if you wanted to have a dissolution. So, in my next subsequent part of my lecture, I am going to talk with you in detail relating to that. Otherwise, statutorily you need to give couple of information, like what is the name of your company, which will be your register office. Then possibly you need to give the objective or the purpose for which you are incorporating the business, and then you have to give the name of the partner who are subscribing this particular incorporation document and their detail, and for that matter you have to name also who will be the designated partner. So, these are the statutory requirement, but these are the benchmarking, but my advice will be you should need to detail out many more than whatever the statutory requirement is. Now, again there is a need to decide about the membership, who will be the partner of your organizations. Now, when you are talking about the engineering startup, the important thing is that there might be many people who are the party to that particular innovation or engineering innovation. In that circumstances, you have to decide that are you going to take everybody as a partner in your business, or some people who might not be interested in the production of that from that particular technology which you have developed, but rather they are interested to exit by getting some kind of a remuneration, or they are interested only for a future remuneration from that particular product. So, in that circumstances, my advice will be do not take that particular person as a partner. Now, I am going to discuss with you, but at the same time you might need to take somebody as a partner who is going to finance your setup, finance your organization or startup. Then in that case you have to see that in what terms and condition he is joining that particular partnership firm or LLP. So, while you are choosing the partner, you should do a proper due diligence or proper exercise relating to the person who is coming into that LLP or in that particular organization. Now, decide about the register office, because the register office is very important from different perspective. It might be important because there might be a proximity of register office with other financial institutions. It might be important because you are doing a business in a particular market, and you should have a register office near to the market or within that particular market itself. So, there is a several externality, or maybe you are incorporating the business of a particular nature which has a particular ecosystem or infrastructure built in a particular place. Like people say that if you wanted to build up engineering startup, then the Bangalore possibly one of the good option, because you will find because of this engineering startup innovation incorporation there is already kind of infrastructure has been created by the state or by the local community, and which is going to facilitate to incubate your startup in that particular place. So, choosing the register office for your LLP is one of the important aspect for the purpose of your business. Now, in my subsequent talks or subsequent part of my lecture, I am going to concentrate more on the matters you should incorporate in the incorporation document. Like I have already told you that there is some statutory requirement which you need to incorporate in the incorporation document, but beyond that you need to have detailing out in the incorporation document. So, your incorporation document should define the terms which you are going to use within the incorporation document. Now, many of the times some of the word which you are using in the incorporation document have statutorily defined, that means, is defined in the act. So, in those circumstances you might not require to define that particular word. But if you want to additionally attribute certain meaning with that particular word, in that case you should define that particular word. Now, many of the time you are interested to define the rights and the liabilities of the partner in this setup, and which is something beyond or more than whatever has been prescribed by the statute. So, I'll suggest you to define those particular words. So, what I am trying to drawing your attention, that something which is not used previously by the by the act or other bylaws, then in that circumstances it is advisable to define that word which you are going to use it, because if you are not defining the word, there is every possibility that it might give 2-3 meaning, and when there is a dispute arise and if you want to interpret your incorporation document or the constitution document, it might lead to further dispute. So, to avoid the dispute in the future, it is advisable that you define the word which you might use in that particular document if it is not otherwise defined statutorily or within the act. Then you should create a general provisions. General provisions will spell out in generally the rights and responsibility and the extent of the business this particular organization are interested to carry forward. And it is advisable that if you can do it under the subheadings, because many of the time you might have the main business which you wanted to incorporate, and to support the main business you wanted to have further business which you wanted to start with. So, in that circumstances you need to define that what are the things you wanted to do, and in that circumstances what will be the rights and liability of your partners. Now, if somebody are promising for the additional capital in the future, and in that circumstance if there is a change happen, then how the relationship will be defined in that circumstances, you might put it into the general condition. Even though we generally deal this particular provision into specifically under the ownership, capital contribution, allocation and distribution, but you can have some kind of a general clauses relating to that in this particular general provision. So, what I am telling that if you do not want to mention something very specific, or you wanted to have some kind of a general conditionality which you cannot foresee at present, but you think that well this is important to have it, then in that case put it into the general provisions, do not put it under a specific headings. So, general provisions you can keep on adding the things which you are not putting under the specific headings. Then the next important thing is the management right. Now, as I have told you that in case of LLP there is a designated partner, and law impose the right on the designated partner that he need to take part in the compliances, and once he is taking part in the compliances, he is basically carrying out the day to day activity, but you can define that what are the activity this particular designated partner can do, what are the activity you need to have a majority partner consent, and in what are the activity all the partner has to agree. So, you can have a detailed management right, who can exercise what kind of right, in which matter the matter need to be elevated to the further level, and in which matter only the majority consensus can work. Similarly, you can have furthering of or detail out relating to the capital contribution, allocation and the distribution. Now, initially you might start with the venture with a small capital, but once the venture grows you might need for a new capital. So, in that circumstances you might admit some of the partner who can bring more capital in the venture. Now, if the people are bringing the more capital in the venture, then what will be the right of an existing partner? Will their right be diluted? or will it going to affect their management right, or how you are going to treat this particular newcomer. Will the newcomer require to give a premium when he is admitted into this particular coming into this particular partnership, and if there is a profit which you are making and some of the profit you are keeping for the growth and some of the profit you are distributing amongst the amongst yourself, then what is the ratio, or up to what point of time you can keep the profit for the purpose of the growth, and after what point of time you should distribute this particular profit. Or you might even think that well, you can continuously distribute the profit without keeping anything for this particular growth, because anyway after some point of time you are going to convert this particular organization into a private company, and then you might sell your venture to somebody else. So, you do not want to re-employed into the growth, because growth will be a natural phenomena, or when the growth will picked up you are going to sell this particular organization. So, whatever the your decision is, what I am trying to drawing your attention, you should have a provision in place, because otherwise this might create a confusion or dispute in the future within among yourself. Similarly, do you have kind of a criteria for admission as well as withdrawal. Like some of the criteria I have talked about relating to the admission, when I said that you have do you require to bring the premium, or do you give do you require to give premium at the time of admission. Apart from that, you might also define that who can be a partner into this particular partnership firm. You might simply say that there is a particular category of financial ventures can be a partner into this thing, or you can even say that there is a kind of a venture capitalist who can be a partner into this particular thing, or even you can say that you are not going to allow any venturers to be a partner into this partnership firm. So, whatever you decide, you need to define this particular thing. At the same time, if somebody is withdrawal or going for a withdrawal, you can decide the timeline that after this particular investment one has to stay back with the investment for this particular timeline, and before that one cannot withdraw. And at the same time, you can also define the procedure relating to the withdrawal. That means, do you require to offer this at the time of the withdrawal your stake to the existing people, and if it is if the existing people do not accept this particular offer, then in that circumstances can you offer it to the third party, and if the third party is admitted, what are the qualification that third party need to have before they have been offered this particular stake, when the stake of the person who is diluting his stake. So, these are the very contentious issue, because many of the time if you do not define this, it might affect your organization or the functioning of the organization in the future. Then further, you need to maintain the books and records as it has been prescribed by the statute or itself, and then you can also further define that who can have access to information. In generally, you need to give to access the information to all other partners, but in circumstances where the stake is got diluted, then can you give this particular access to other person, or when the partner has transferred the interest temporarily as a part of the security, will you going to give access to these books of account. So, whatever you do, you have to define that particular issue within your books of within your incorporation document itself. Now, then you can talk about the sharing of the profit and loss ratio, and this particular thing can go with a different kind of a calculations, because please to remember, which I have discussed with you in the last lecture, that whenever the partners are making the contribution, and as the statute provide, you are not necessary that all the time you have to bring the cash or the kind which is equivalent to cash. So, if that is so, if you are bringing the technology, or if you are bringing some other kind of expertization into this particular firm, how you are going to get the profit, or if there is a loss happen, then how you are going to share that particular loss, or if you think that well, you are not going to share the loss at all, or is it possible to have that kind of remedies available with you. So, whatever the condition is that you need to define it within your incorporation document. Then you can talk about the termination, dissolution and the liquidation. In what circumstances you wanted to put to an end your organization. Are you incorporating the organization for a particular specific purpose, or you think that well you are incorporating this particular LLP for a specific timeline, specific duration or specific matter to achieve, then you are going to sell this particular LLP, and or you want to convert this particular LLP. So, if you have something, it is always talk about if you have kind of a timeline planning relating to this particular LLP. Now, relating to the borrowing power, that in what circumstances you can borrow the money and from which are the people from whom you can borrow this particular money, you can define that. You can restrict for the companies, restrict the LLPs or the designated partner or those people who are in the management of this LLP, that in which circumstances they will be allowed to borrow and in what are terms and condition that you can let down within your matter of incorporation. Then there can be a banking operation. Banking operation means who has a right to operate the bank account or the account which is there in the financial account. That means what I am talking about, that if there is any financial transaction, who is going to be in charge of that particular financial transaction, or are you going to have kind of a division for this particular financial transaction, so much so forth, that you can define within your incorporation document. Now, next important issue is relating to the intellectual property and the technology issue. Now, if you are bringing the intellectual property, then in what terms you are bringing the intellectual property in that particular form? Are you giving it as a exclusive license? Are you giving it as a non-exclusive license, or you are absorbing that particular technology within the firm itself? And if somebody is further developing on that particular technology, then what kind of right those people who are there in that firm at that time can enjoy, or you are going to have that exclusive right on the development and the promotion of that intellectual property, or do this particular firm has a right to transfer the intellectual property to the third person and to earn the revenue out of that particular thing, or do this particular firm can further acquire the new kind of intellectual property or the technology, and what terms it can be acquired? Can they go for a joint venture in the future with similar kind of a firm? So, whatever you wanted to do relating to the technology and the intellectual property, that need to be detailed out. And then the important thing is the dispute resolution. It is always advisable that whatever the dispute which you have, you should have kind of a mechanism to resolve that. Now, the statute itself provides kind of a mechanism for resolving the dispute, but in addition to that, you can have a mechanism in place. You can even define that what kind of a dispute you can resolve by your own, and what kind of a dispute you can refer it to the external agencies which are beyond the organization, or you can also recommend for a particular type of setup of dispute resolutions among the members of that particular organization too. And apart from that, you can have a many miscellaneous provisions. Maybe it is relating to the business operation, where you wanted to operate the business, how you can scale your business. It can be relating to entering into a new market, it can be relating to the strategic alliance which you wanted to form, it can be relating to managing the regulatory responsibility, so much so forth. So, whatever you think potentially going to have an impact over your business, you can detail out all those particular things in the incorporation document itself. Now, apart from that, as I have told you that this is the legal entity of or it is a more a formal entity. In this particular case, you need to manage the compliance requirement, which I have talked with you in the last lecture of mine also, and at the same time you also require to file whatever the requirement to be filed with the different regulator into this particular thing. But one thing I like to tell you that you do not have a flexibility in case of the LLP relating to raising the fund as you have in case of a public limited company, but you can take somebody as a financier or the venturers or as a partner into your firm for financing your organization. Thank you.